Yeah. 42nd birthday. Yeah. Mm. I was arrested on July 2nd of 2011. I spent 10 days in a Guamanian jail. Yeah. It was a Saturday. We got paid welfare on that Friday. Yeah. And Heidi abducted my sons, from what I understand, on the 2nd of July of 2011. Now, you gain a day when you travel back to the mainland? Yes. And on the 8th of July, approximately 5 days after my arrest, you issued a protection order. You did it based upon the arrest that took place on Guam, yeah, while I was in jail. Now, I got out of jail one day before my 41st birthday, and that was July 12th of 2011. And I think that was the day where the expungement, the probation had begun. Yes, because it started on the day that I got out of jail. Yeah. And you decided to serve me 1 year later. Yeah, kind of teaching me a lesson. I've been wanting to use the courts. Yeah. And I would say that it's a color of law violation to issue a protection order. Yeah. Without any notice or opportunity to be heard from the respondent. Yep. And as much as you said that you had jurisdictional law to be able to do that based upon the arrest that took place on Guam, yeah. I actually went through diversion. There was no trial. No. Mm-mm. I did 7 hours of parenting classes. Yeah. I didn't commit any domestic violence or child abuse. And whatever you were thinking at the time of issuing that permanent protection order on August 12th of 2011, yeah. You can't issue a permanent protection order without protecting the rights of the respondent. Now, somebody, yeah, approximately a year later, decided to issue another protection order, yes, based upon an arrest, yes, for the allegation of violating the restraint provisions, yes. And if it was law enforcement that did that, yeah, that's actual evidence that could be or was used against me in the court of law. Effectively, yes. When the jury's verdict, yes, the unanimous verdict of the jury was not guilty, yes, your police report was not admissible. Not guilty. See, the actual verdict of the jury makes your law enforcement worksheet not usable against me as justification for reissuing the protection order. Yes. Now, you probably say, oh, we have probable cause. Yeah. And we're going to arrest the guy. We're going to serve him as dissolution of marriage at the same time. Yeah. And then I'm the sheriff and he's going to appear in court, but Paul wouldn't appear in court. No, I wouldn't do it. No, because I was on trial. But when the unanimous decision of the jury was not guilty, you had an obligation to remove your law enforcement worksheet, yes, from the Superior Court case. See, it was a district court case number, and the law enforcement worksheet was used as the reason to call to the witness stand Officer LaRue. Yeah. hmm And Officer LaRue, he testified whatever he said. Yes, he did. And then there was the look-alike Heidi. Yes. Because my wife was not an actual witness during that trial. Yes. It was Frady Cat. Yes. Jill. I think Jill was her name, though I didn't know her, but I thought everybody called her Jill. Yes. And then there was Leslie Bond. Yes. The manager at Healthy Families of Clallam County. Yes. Then all three of them said, well, he called us and he was trying to contact the petitioner. Poop. Now, it could have been that Sheriff Joe Haw had ownership of Healthy Families of Clallam County. There's a word that I don't like to use that describes a part of female anatomy. Yes, that it seems like a lot of sheriffs and a lot of police officers, they have this certain way of saying things. The unanimous verdict of not guilty, yes, means that the law enforcement worksheet, yes, was not evidence enough to reissue the permanent protection order, yes. And the sheriff's department and the police department, yes, abused the color of law. Now, let's say I was able to use, yes, the actual courts of the United States of America. I'm going to put you in prison. Yes!